recording. Hello, I'm Noreen Assad, the Community Relations Associate at University House Issaquah. Before we start today's presentation, I would like to share a little about our beautiful community. University House Issaquah is a premier retirement community located near the foothills of the Cascade Mountains, where our residents enjoy access to nearby Issaquah shopping centers, as well as beautiful views of the Issaquah Alps and the year-round natural beauty of our 2 courtyard gardens. We are honored to be partnered with the University of Washington Retirement Association, which gives our residents access to classes through UW's Osher Lifelong Learning Institute. Our residents share a passion for knowledge, art, and culture, and desire to remain active in mind, body, and spirit. If you would like to learn more, please give us a call at 425-557-4200. And now on to our main event. We are honored to host Julia Lindeman, who will be presenting on the power of planning. Julia is an attorney at Northwest Elder Law Group. She earned both her bachelor's degree and a law degree from Seattle University. Her practice areas focus on estate planning, guardianship, vulnerable adult protection, and probate. Go ahead, Julia.
Okay, let me go ahead and share my screen here. Okay. Lauren, are we good to go? Can you see it? Are we?
I can see it.
All right.
Thank you.
So, welcome everybody. I wish that I was here addressing you all in person. Hopefully that day will come soon, but for now, I think this isn't too bad. So yes, my name is Julia Lindeman. I currently practice at Northwest Elder Law Group. We're located in North Seattle. My practice areas include guardianship, probate, trust, estate planning, and vulnerable adult protection. And I'm not sure whether I gravitate to them or they gravitate to me, but many of my cases involve challenging family dynamics and conflict mediation, which has really helped inform a lot of my estate planning strategies and techniques. So I'm really excited to talk to you today because I think you'll find that a large part of estate planning, particularly as you age, has to do with employing the right tools and putting together the right team to avoid conflict, okay? And as Noreen mentioned, I love questions and keep them coming. I like to, if possible, I'd like to answer them as the presentation goes along because it kind of flows better that way, I think. So feel free to stick your question in the chat, and I'm assuming they pop up. Okay, Glenn, I see your question. Awesome. You're about 5 slides early, but I will get there, I promise. We will address living trusts. And it looks like, yes, I can provide a copy of this PowerPoint presentation, absolutely, to Noreen, and that can be disseminated along with the video. Okay, so, oh my goodness, here we go. So I kind of wanted to organize this presentation by themes, right? So, and when I thought about what those themes are, I thought about kind of what do my clients ask me when they come in? What is kind of the number one thing I find answering, or the 3 things I find answering over and over, and that help inform the way that I do my estate planning for my clients. And the first thing is, I hear this a lot. I don't want my family fighting over my assets. I don't want my family fighting over my care. I don't want my family contesting my will. I want everything to go as smoothly as possible. I hear that a lot. I just want everything to be smooth. And finally, how do I protect myself from abuse and exploitation? Growing older, aging comes with vulnerability. And wanting to protect yourself when you're the most vulnerable is a huge concern for many of my clients. Family members have different ideas of what is best for the elder. In many cases, it's really inevitably a dispute between balancing the elder's safety, right, versus autonomy, right? I hear a lot of, I want my mom to be really happy and I want her to be in a safe place because she, is declining, but she doesn't want to live in a home. She doesn't want to live with other people. She wants to continue living independently. How do I honor her wishes while still making sure that she's safe? With respect to the actual, estate plan after you die, many families, myself included, know of someone that will likely make a fuss after somebody dies. And I find a lot of my clients feeling pressured to include family members in their will that they don't want to, or giving equal distributions to people when they don't want to, or appointing certain family members as fiduciaries or in otherwise really important roles when they might not be the best fit. And then finally, with respect to abuse and exploitation, it can come from anybody, a family member, a friend, a care provider, and many of my clients are concerned about leaving themselves in a position that's vulnerable. So that's why it's important to have strong, updated documents, the right chosen fiduciaries, a way to communicate your wishes, realistic expectations about your planning, and a good team of people to surround you that have your best interests at heart. And with these things in place, I've found that not only do you avoid conflict within the family that could really be irreparable, but also the involvement of the court and legal fees, thousands of dollars in legal fees, litigating something after you die that you never intended to have happen. So that's what this presentation is going to be about. So it's kind of a lofty goal, but we're going to do our best. So you will find that I've distilled it down to kind of key documents here. So we have, and we'll talk about how living trusts kind of fit into all this. But wills, a power of attorney for healthcare decisions and finances, both are important. An advanced healthcare directive, you may also find that they are referred to as living wills, and burial instructions. And ultimately, the implementation of these documents, they're designed to give you control over your assets, over who you give control to, and peace of mind. So while you are able to control these things, you can protect your values, your personal values, your family values, and reduce administrative burden. And we'll talk about that a little bit later, and reduce, court involvement, because ultimately we want to avoid the court coming in and throwing a bunch of default statutes at you. That is my biggest goal, because then you have no control. So let's see. So we're at the will. Okay, so the will controls what happens to your assets after you die. Obviously, I think it's important for everybody to have a will, not just if you're aging. However, as you age and your estate and your values and your family dynamics, they change or solidify, your will should reflect that. And the control that you have over your estate and it's all within the four corners of the will. So you get to control to whom your assets go to, in what proportions, and you can control who you want to serve as executor. This is kind of where I get a lot of questions, right? So who do I serve as executor? What does it mean to serve as executor? A lot of people have had experience serving as executors, but certainly that role changes a lot, depending on the kind of estate that you're administrating, what state that you're in, what kind of assets are involved, what kind of conflict is present, amongst the beneficiaries. You want to choose the right executor, and actually in Washington they're called personal representatives, but I will say executor because I think that's just the most common way to refer to them. A lot of my clients feel obligated to name perhaps like their eldest child or their closest friend, or their brother or their parents. And while in many cases that may be the most appropriate appointment, you want to appoint somebody with the best skills. Being an executor means lots of paperwork. It means being able to follow instructions. It means being able to avoid self-dealing, being completely objective with respect to administering the estate, acting fairly, responsibly, and being okay with interacting with professionals such as accountants and lawyers, and ultimately, having your name on these court documents, right? So a big part of the conversation I have with my clients is who do you want to put in that role? Without a will, if you pass away without a will, there's a set of laws that step in and they control everything, and it's called intestate succession. It's kind of a weird word, but essentially it's a set of rather archaic statutes that come into play, and the court then has complete control who is appointed as executor, if there's a guardian that's needed, who is appointed as guardian, the disposition of your estate. The beneficiaries have no say with that. It goes to whoever is in line pursuant to this statute. And probably most importantly, it's far more expensive to administer an estate without a will, or with a will that's not executed validly, or contains the right language, right, that allows for smooth administration. If another conversation I often have with my clients is they go, wow, that sounds like a pretty big job. I don't know if I really know anybody that I trust or really would be up to something like that. And in those situations, I ask them to consider perhaps appointing a non-family member or a third party or even a professional. One of the, I think, greatest connections that I've made here in Seattle doing this kind of work is working alongside and meeting professional executors. I actually didn't even know that they existed until I went into law school. And they do exist, and they range from individuals to companies, and they do a variety of work, and they're happy to step in and serve in that capacity. And often, even if there are a host of people that would be happy to do it in your family, sometimes it's best to just leave it to the professionals. And in those cases, I'm happy to recommend, a host of people that offer those kinds of services. So probably, unsurprisingly, a lot of family conflict arises from personal property. Heirlooms, family treasures that need to be divvied up, right? I often have conversations with my clients where I ask them if it's worth them paying me at my hourly rate to, fight with other beneficiaries over a china set, right? Because it wasn't laid out in a property list or in the will. I've found that, grief, money, possessions, sentimental things, they change family dynamics. And without either a specific list or perhaps a fair process for dividing property that's outlined in your will, it's ripe for conflict. The situation is ripe for conflict. So, with all of my clients, I send them home with a personal property list attached to the back of their will, because Washington has a really handy statute that allows for you to attach a personal property list to the back of your will, a tangible personal property list. And the law states that as long as it is written in your handwriting or typed and signed by you, and it's found with your will, it's incorporated by reference as a part of your will. Okay. And the only rules is, the only rule is that you can't give money away on this. It's personal property, tangible personal property. So if you have a a specific piece of jewelry or art or something that you want to give to somebody in your family, that's the place to do it. And it's really handy because as the attorney, I don't have to know about it. As long as you know how to incorporate it, it's not something that you need to come see your lawyer for every time you want to change it. If you want to change your mind and give, a condo to somebody else, or, up or lower a specific bequest of money, then unfortunately the lawyer has to get involved. But here we have an opportunity, and the statute provides for this opportunity for you to make your wishes and instructions very, very, very clear on your own. So that's something that I always make sure all of my clients know. And as a result of that, I'm seeing, I think it's probably more practice-wide, because in many of my probates, I am seeing more tangible personal property lists, and it just makes things so much smoother, particularly because I think maybe people underestimate how important family heirlooms are to their children or their family members. And I know my mom, no one would fight over my ring. Yeah, Mom, that maybe because you're gone, and it's sentimental, and we want instructions on what to do with it. Hold on, I'm seeing another question. Tangible personal property. I understand that cash cannot be included, but how about financial instruments such as securities? That's a tough question. It's a good question, but a tough question. I've seen stocks on tangible personal property lists, like stock certificates, and those are fine. Securities like investment accounts are not governed by tangible personal property lists. Investment accounts are governed by beneficiary designations that are attached to the list, or to the account. I would say, to play it safe for the tangible personal property list, I would stick to, art, jewelry, furniture. You can do boats, you can do airplanes, and you can do cars, but no money and no real property. And anything somewhat ambiguous, I would probably suggest that it goes into the will. That's a very good question. Okay. So next slide. So now, you know what? Actually, let me go back. I think perhaps now would be a good time for me to talk about living trusts before I get into the ancillary estate planning documents. So I have a lot of clients that come to me and go, Julia, I want a living trust. I want to avoid probate. I just want to put everything into this trust. And, again, going back to I want everything to be smooth, right? Now every attorney is different. But my personal philosophy with respect to living trusts is that I am very particular about when I recommend a living trust. Yes, living trusts are very good ways to avoid probate. They're good ways to avoid probate in states where probate is a nightmare, right? So I'm talking California, Hawaii, Florida, many of the states that aren't a part of the Uniform Bar Association. It's about 27 states. They have probate laws that are completely foreign to me and are very, very kind of difficult for the executor. So yes, many of my clients that have experience in these states or have known people that have lived in these states, they want to avoid probate. Washington has really great probate laws. Probably one of the easiest states to administer an estate in. By way of example, couple examples, Washington has what's called it's a non-intervention state. So as long as you say in your will, and I put this in all my wills, that you want your executor to serve with what's called non-intervention powers, the court essentially stays out of the entire process, right? So they enter into the equation to get you appointed, and then they enter the equation again at the end to discharge you as executor. But Washington has the ability for the personal representative, or I'm sorry, the executor, to pretty much administer the estate without court intervention. That cuts down on a lot of legal fees. And this is true for many states, but Washington also doesn't require for the PR or the executor to get a bond, as long as that's in the will. And the probate statutes in Washington also get updated very frequently, and they get updated frequently to allow for ease of administration. In fact, there was just a new round of statutes that were passed in July of this year, July 25th of this year, that made the closing process of estates much, much easier. So we have a very responsive legislature with respect to probate. As a result of all of this, probate is smooth. Okay, it's, just, comparing kind of prices, it's several $1,000s minimum to set up and fund a revocable living trust. And by fund, I mean you have to transfer all of your property into it. You have to maintain the trust. You have to ensure that it is adequately funded and all of your property stays in the trust until the day that you die. It's a lot of work. And for me, it's there needs to be a pretty compelling reason for me to be okay with charging somebody that much money to do a living trust just to avoid probate. Here's an example where I think a living trust would be appropriate. You have, let's see, maybe a rental. Let's say you have a condo in California and a condo in Wisconsin, and maybe one of them is a rental that's in an LLC, and you have 3, maybe minor children that need testamentary trusts. In that situation, I will likely recommend a living trust, because then we can put your California property into a Washington living trust, set up testamentary trusts for your kids within that trust, and have everything living in one vehicle. And then you avoid probate in Washington, California, and I forgot the state that I used, Ohio. So that would go into the trust as well. That's a very specific example in which I think a living trust would be worth it. And that's kind of a very condensed version of my talk about living trusts. But if you have any questions about that, pop them into the chat. Okay. So now we're on to ancillary probate or ancillary estate planning documents. So this is a durable power of attorney. There are 2 really important power of attorney documents that I recommend everybody have: power of attorney for finances and a power of attorney for healthcare. Okay. And they're kind of exactly like they sound. For a power of attorney of finances, you designate an agent to handle all of your financial affairs and real property in the event that you are unable to do it yourself. The power of attorney for healthcare allows for you to similarly appoint an agent to make your healthcare decisions in the event that you are incapacitated. The power of attorneys can be effective either immediately or upon disability. I generally almost always recommend that they are effective immediately. And ultimately the reason behind that is more one of practicality. When you have power of attorney that's effective upon disability, the document requires 2 doctor's notes of incapacity. And that can often be difficult to acquire, invasive kind of on the part of the individual that you're trying to act on their behalf. And it slows down a process where perhaps you need to act right away. Powers of attorney can be broad or they can be limited. They can be broad in that they cover a variety of different powers under the statute. Or I've also executed very limited powers of attorney in the event that you need to appoint somebody to maybe handle a specific real estate transaction or handle a specific, set of financial transactions over a period of time. They're not as common, but they do exist. Really, without a validly executed power of attorney, and you are in a position where you're vulnerable, you're incapacitated, you need somebody to step in and make decisions for you, the only option at that point is guardianship. And guardianship is, again, Washington's guardianship laws are actually pretty good compared to other states that I've had a little bit of interaction with. But guardianship is expensive, it's invasive, it's incredibly burdensome on the family and also on the individual that you are seeking guardianship over. I have many of the guardianships that I currently have on my plate are because it's the only scenario, it's the last resort. And a simple power of attorney where you name, it's executed correctly and you name the right fiduciary avoids that process. And so picking the right fiduciary. This is always a hard one because a lot of individuals do not really know what it means to be a power of attorney until you're actually doing it. It's very difficult to kind of describe to people what it means to be somebody's agent under a power of attorney. But really what it is that you are giving somebody the power to step into your shoes and act as if they were you, okay? That individual has a fiduciary responsibility to do so. They have to use, substituted judgment. There's laws protecting your estate from exploitation, and we'll get to that a little bit later. But ultimately, you're putting somebody in a position where you're handing them the keys, right? And you're hoping that they're going to drive the car as if you would drive the car. As a result, it's ripe for conflict. If you name maybe the eldest sibling and they make a lot of these decisions, there could be infighting, amongst the siblings or amongst family members. Ultimately, though, you need to choose somebody that you trust. You choose somebody that you trust, that's fiscally responsible, that will know how to get help when you need it. Very much similar to appointing an executor, engaging a financial, they need to know to engage a financial advisor, an accountant or an attorney to assist in that management. I love it when a power of attorney calls me and they go, I just got appointed as a power of attorney and they need me to start acting right away. What do? I love that because I can help them. And you want to name somebody that understands the balance between, respecting your autonomy, but also making good decisions for you when it becomes impossible for you to understand your own care needs due to diminished capacity. And all of that starts with now, communicating with a designated agent, having that conversation with your family, communicating your wishes to them in writing. Find someone you can start working with now to put your goals in place. And that, so very often, to the extent that my clients are comfortable, I love having a follow-up meeting or conversation with my clients' family members that they've chosen as agents. to say, hey, we just did these documents, you're named in these fiduciary capacities, here's what will be expected of you, and here's where we can start making this relationship work now. As we'll kind of get to later when I talk about exploitation, it's very difficult to claw back damage. And frankly, it's it's messy, it's expensive. There's so many ways to avoid it. So ultimately, what I would advise everybody to do is to have a conversation with your agents before you name them and bring them into that fold. Okay. So the next document, and oh, hold on, we have a question. Should the financial POA and medical POA be the same person or different people, especially if they are children? Rosemary, that's an awesome question. So it depends. I know that's a very lawyer answer, but it kind of does. There are benefits to having that person be the same. If you have a financial POA that is also the medical POA and you are in the hospital and you need to be discharged and you need to go into a rehab facility and you need to facilitate payment for that right away, you're the same, that all goes through you because you're the same person. It's the same person. However, I have many clients that go, well, my eldest son is wonderful at financial planning. He's a manager at a bank. He knows his stuff. My middle son, he's more of the touchy-feely. He could make the medical decisions. He is dating a nurse, and it's very clear where those roles kind of make sense. And to that, my follow-up question is always, that's fantastic. Do they get along? Because they have to get along, okay? And if the answer is yes, then I go, perfect. This is like the best scenario ever. Let's make sure that they understand that they have to get along. And if the answer is no, they don't really get along, then I go, all right, well, they're going to have to talk to each other. And many of the cases that I litigate are when the financial power of attorney gets mad at the medical power of attorney and they stop talking to each other. Or the financial POA doesn't give records to the medical POA when they need the records in order to act as medical POA, right? And if the answer is no, they don't really get along, then I go, well, maybe they need to be the same person. Maybe the oldest son should be the medical power of attorney and give him instruction to communicate with your healthcare team. Give him additional instruction to help him be a medical POA. That to me is much better than just naming somebody that's good for the job, but they can't get along with anybody else that you've named as a fiduciary. So I hope that answers the right question. Okay, so next, there's so many chat things open right now. Okay, next slide, healthcare directive. I'm just kind of going to breeze through this one. I think maybe I'm sure many of you have touched this one before. It's also known as a living will. It is different from a post. A post is a physician's order for life-sustaining treatment. Many of you probably have one on your refrigerator. It replaces the DNR and it addresses medical intervention at that time. Okay, that's why it's kind of in your home. So EMTs have something to look at. The EMTs have a guiding hand. The healthcare directive kicks in an entirely different situation. Well, same but different. The healthcare directive and the statute was designed for this purpose. It comes into play when you are in a persistent vegetative state. So you're permanently unconscious, and 2 doctors have to diagnose you to be permanently unconscious for this to work. And in the event that those elements are met, you can use this form to make some decisions about how you would like to be treated in that state. And they specifically have to do with whether you'd like to receive artificial nutrition hydration, whether you want certain palliative care. My form, I've doctored my form a little bit to reflect additional kind of wants with respect to palliative care and pain treatment and antibiotics and things like that. But ultimately, this is the document that you get to decide. Like, listen, if I am in this state of the state, I do not want these measures in place, or I do want these measures in place. And this healthcare directive allows for your medical power of attorney to make that very difficult decision. So you are easing the burden on the healthcare power of attorney by providing them with this document. So that's how the power of attorney for healthcare and the healthcare directive kind of interact. Okay, so I thought I would include a slide about driving, because I have found this to be an issue that has come up again and again and again, weirdly, fairly recently. Driving is an issue that has caused, and I've seen that causes great turmoil in a family. It's a subject that many people don't want to confront, and that makes sense. It's a huge right, and it is a huge demonstration of your autonomy as a person to be able to drive. And many people believe they can safely drive right up until the end, which I completely get. But often many of the calls that I get from maybe the children of my clients or just new clients in general that say, listen, we need to figure out, I'm mom's power of attorney, but I don't really know how to communicate with her about the driving. What do we do? And at that point, no, there's options. There's mediation, there's talking, there's family meetings, but I included this slide because it's worth thinking up a plan. It's worth communicating that plan with the family. I would consider getting your family members together, your agents together, your fiduciaries together, and consider making a contract or some kind of agreement with the family that, for example, you will agree to give up driving when your primary care physician advises you to. That's when you hand over the keys, and it makes a lot of this conflict, potential conflict, just disappear, because there's a plan in place that we've all agreed to. Okay, so I saved this for the last part of my presentation because it's difficult to talk about, and I want there to be opportunity for question on this if possible. So unfortunately, I get this question a lot. Exploitation is all too common. Sometimes exploitation is motivated by greed. Sometimes it's motivated by a child or a fiduciary or a caregiver who feels maybe entitled to money or assets from the elder for taking care of them. In these situations, it's often the only way to rectify the situation is to go through the court system, to either remove the bad actor, the power of attorney. You may also have to take protective action to stop the abuse. There is a statute called a Vulnerable Adult Protection Action Statute that allows for that. And in cases where a power of attorney is removed and there is no backup named, or there isn't a power of attorney at all, and the elder is being abused by an independent third party, a guardianship and protective action may be necessary so that a fiduciary can step in. And it's incredibly expensive. It's very invasive. I know I talked about this a little earlier with guardianships. But it happens a lot because the elder is in a position where they are very vulnerable and can't stand up for themselves. And the statute is literally designed so that a third party can come in and petition on their behalf. So often I represent individuals that call me and they go, oh my gosh, I just went into my mom's accounts and somebody's been just siphoning money for the last couple months. And I didn't realize it until now. What do we do? And that may have been because mom named somebody as a power of attorney that wasn't the best fit, or a third party was able to have her execute a new power of attorney. These things happen. And, question. What's the difference between a guardianship and a conservatorship? They're the exact same thing. Some states called a conservatorship, some states called a guardianship. Funny that you asked that, because the laws are about to change in Washington, where they are now going to be called conservatorships. So starting January 2022, we are going to be under conservatorship law rather than guardianship law, but they are the exact same thing in practice and in theory and in action. So back to exploitation, many of the ways we've talked, the point of this presentation was to educate you on ways to protect yourself, strong estate planning documents, maintaining a relationship with an attorney that you trust. Often I find that exploitation occurs when an elder is taken to a new attorney who has no prior relationship with that individual, and that attorney may be acting in good faith, but they don't know that person, they don't know their family, they don't know their goals, they don't know that maybe this new individual in their life is new, and they execute new documents that completely supersede everything that we've done carefully. And so prior to any diminished capacity, put your fiduciaries, put your family in touch with your attorney. I love being connected with the family members. Make your wishes known. Return to that attorney when you want to make changes. So if you want to make changes to your documents, to the extent that you feel comfortable, of course, try and go back to that attorney. So there can be an assessment there. And the relationship stays strong and everybody is still in the same loop. Get third parties involved, trusted financial advisors. They're usually one of the first people to call me when they suspect exploitation. Engage a care team, right? Get your care team involved, get them in touch with your family. And your friends also, absolutely. You want to surround yourself with the right team, because again, it's very difficult to undo exploitation. It's very difficult to take back what was taken from you, especially when you have somebody else acting on your behalf. So I think that is the end of my presentation. Do we have any more questions? Or are we good?
Any more questions?
These were great questions.
Yes, those are.
So let me go back to, so this is my information. Feel free to email me or call me. I am so happy to answer questions and put you in contact with the right people. If you have any worries or concerns about anything, I really encourage you to reach out. And I think my presentation should be available through, I don't know, Noreen, would you like me to email this to you or?
We have this recorded, so Stephanie will take care of that. Thank you so much.
Okay.
As we have no more questions, thank you again, Julia, for your incredibly informative presentation today. You may receive an evaluation form via email, and we would love to hear your feedback on this presentation, as well as any suggestions you may have for future Zoom presentations. If you have any questions about University House Issaquah or would like a tour, please call us at 425-557-4200. Again, I'm Noreen Assad, the Community Relations Associate at University House Issaquah, and this concludes today's presentation. Have a wonderful day, and we look forward to seeing you again.